everybody. This is another episode of Targeted Justice v. Garland, a podcast about an extraordinary lawsuit. And today we have important updates. And with us today, my dear friend, General Counsel for Targeted Justice, Anna Toledo. Anna, good morning.
Good morning, Len, and good morning, everyone watching. Thank you for being here.
It is an important episode, don't you think? It encompasses almost 2 years of genuinely extensive work and that you demonstrating a real grasp on the issues. And I think that the petition to the Supreme Court read like a manifesto. So let's start the presentation, and I want all your comments. Today's podcast is called SCOTUS and Other Legal Updates. Let's get to the um, episode. We finally heard from the Supreme Court. This appeared on the supremecourt.gov website. There's a number, there's the title of our lawsuit, and October 7th, 2024, petition was denied. We extremely upset about it, but it doesn't change our resolve. And I think your reaction that you expressed in your blog was just spot on. You wrote it on October 8th, just following the decision, and you can either read it to us or you can paraphrase it. It's up to you. But I want to get your temperature on this decision.
Yeah, I'll read it because I think it's like you say. I think it's important that people hear it. I admit that I was naive to think that such a clear-cut, straightforward, documented complaint would effortlessly bring down a criminal program that has operated for more than 20 years. After all, loyal to the ethics that rule the legal profession, I would never, and I emphasize never, file a case I was not certain that I would win. Despite this setback, I remain standing tall, proud to be a freedom fighter and met many others in this crusade, to have overcome unimaginable adversities along the way. Let me remind you, my computer getting hacked and encrypted. Let me remind you, the clerk's office in the Southern District of Texas not sending the full record, the defendants, uh, getting transferred to Houston from Victoria, even though the judge Tipton on the first order said that he found our petition for preliminary injunction meritorious, and all of a sudden the case was sent to Houston. Well, I can go on and on, but and I'm making that list. But what matters is that, uh, like Richard Lighthouse says, this lawsuit is going to be in the books forever, and people will know who called on the criminality of these government officials doing this and how the courts turned their back on people that were pleading for their constitutional and human rights. And history will know who it was. I am deeply grateful for the support of those courageous warriors that have stood by me, have withstood adversity with dignity, and refused to give up on reclaiming our freedom. And here I have to also say that the criminals were very successful in infiltrating, disrupting, and dividing our community, having people from our own community attack us when we were fighting for everybody. And that is something that you should think about twice if you engage in that conduct, because we're only fighting for everybody's freedom. And it's a shame that some people went the other way. Len?
I agree. You're reading my mind. I wrote something down that I would like to say at the end of this podcast. But in the meantime, just capping this topic of Supreme Court refusal to look at the case. Do you have, in terms of strategy, we're all disappointment, but was it a right strategy? Uh, to me, the fact that they went so extensively, openly against our case, trying to dismiss it, and they were successful. They dismissed it in the district court, just like you described. They moved the case to another court that went completely with the government strategy. And then at the Court of Appeals, the same. To me, that manifests that the strategy was absolutely correct. We push all the right buttons. And it just, unfortunate, but it will take time, but we will get there. What about you?
Well, I have to remind you that attorney for the Department of Justice and the official capacity defendants, Natalie McMahon, told me on a Friday afternoon before her motion was due on a Monday, this case is going to get dismissed anyways. And I repeat the same exact words all the time because I have them recorded in my head. How did she, 2 months before the case got dismissed, was so certain? As an attorney, I have never been certain that a court is going to act in any way, which way, particularly an attorney that took the bar in 2020. You see what I mean? It's ridiculous. Why? She knew something that we didn't, and that is something that history will judge. History will judge. I am not going to stop, as we will talk in the I'm not going to disclose everything that we're going to do. I'm going to file a petition for rehearing, and I think that after the election happens, many things are going to happen, many positive things for us, because this is, if anything we have accomplished, if there is one thing that I think you'll agree with me we have accomplished, is that in the past 2 years we have brought to the public arena, even though much more awareness needs to be raised, but we uncovered Pandora's box. It's out there. And whether a lot of people are either mind controlled, threatened, or a colluding to preserve this program, the truth is out. And it's very for me I think it's gonna end soon. It has to end soon, because such a program can only work if it's secret. But once it's out in the public, then I think it'll be eroded, and it'll be ended soon, hopefully.
Yes. And I just want to emphasize how grateful we all are for you taking the torch and carrying to the finish line. It's a monumental accomplishment for anybody, but especially while you've been targeted, you were still fighting for us. You were still uh, delivering this strategy that is uh, that it will work, because we're not the only voice. We will talk about it later, all the care initiatives and other lawsuits. But let's go to the um, events in a different lawsuit, because Target Justice filed three more lawsuits. They're FOIA related, and in one of them, there's some movement. So on March 4th, 2024, we filed a FOIA lawsuits, and we nickname it. If you want to go back to episode 55, we called it "Dead People Have No Expectation on Privacy." So what happened is, back I believe in 23, um, Target Justice filed a FOIA request and it was denied. And what we were asking for is to provide records of persons that have been removed from the terrorist screening database in handling codes 3 and 4 after they died. And the argument is that, yes, because they're dead and that people have no expectation of privacy, we can obtain these records. And here's what transpired recently. on September 11 of this year, defendant filed a motion for summary judgment in their favor, which means dismissing the case. And on October 2nd, we, the plaintiff, filed an opposition to the motion for summary judgment. And what's really interesting, and you hit the nail on its head, we looked at the documentation and we realized that the response for the original FOIA request in 2023 was written by Michael Sadel, section chief record information dissemination sector person. And then the declaration that the defendants used to support the motion for summary judgment in their favor, dated August of this year, was also written by Mr. Sadel. And the declaration by declaration by Michael Sadel in this lawsuit contradicts his response to FOIA. It should be 2023. Sorry about the typo. So I want you to explain. I summarized that, but please explain in your own words your finding because you wrote a brilliant opposition. Please tell us about it.
Well, one of the things it should be bothersome to everyone is that this man, who is the chief of the FOIA section in the FBI, he denied our FOIA requests, alleging all these inapplicable exceptions, like the privacy, which we already knew that dead people don't have privacy. Also, law enforcement privilege. Well, handling codes 3 and 4 are people without reasonable suspicion, so there's no applicable law enforcement. And all of those, a myriad, like 10 exceptions. But then in his sworn statement, he doesn't invoke a single one of them. And the attorney also signed a motion, the answer to the complaint, alleging the same exceptions that now they don't invoke because they know that they were set forth erroneously, and to obstruct the production of documents that are susceptible to being produced under FOIA. So in his statements, he admits, yeah, we could produce the documents, but it would take a little effort because we'd have to coordinate among offices. That's basically what he says. The records exist, and the defendant has located them where they are. They know where they are. They know what it takes to put them together. Oh, but it's he doesn't even say it's too hard or too much work. He says it would take the effort of various offices, and they have not produced a single record. So unless a court orders them, they're not going to produce it. I
Yeah.
opposed the motion and I asked for discovery, for a motion to compel, because a targeted justice is considered under FOIA a member of the press. So every day that the documents are not produced, targeted justice First Amendment rights are being curtailed and harmed. So and then last Wednesday, they filed an opposition, saying that we don't even have to produce create documents, basically. So let's just hope that truth and justice, you know, shines and comes through. Len.
Agree. I put on the screen this reply by the defendants. It was filed on October 9th, so just a couple of days ago. And they were talking about this real caveat, the difference between the central record system and the record information dissemination section, RIDS. So the gist of this argument is that the central record system responds, it retrieves records of the persons, of specific individual names. And we didn't file any a request for specific names. We just said, show us the records in this category. So they said, okay, we're not going to use the system because he didn't provide the names. So we will use the different systems and we will search the TSC records. However, TSC records do not contain details that you are asking for. So this is it's a very concocted and it's a twisted into a pretzel argument.
Disingenuous.
Exactly. So on the bottom, in these two blue boxes, I kind of responded myself. I had these questions. I there at the FBI argues that plaintiff did not create a fact issue. We didn't even create the fact issue. The fact issue was created by Office of Inspector General in their audit reports when they're talking about this removal of the record. So this is a the issue is out there, and Target Justice is not the first one who put it out there. And then the second side of the issue is the proposition that FBA is incapable of retrieving the records is laughable. I mean, if they needed these records, don't you think they would create a search that would retrieve these documents? So they can do it for them, but they cannot do it for us. But they're just an executive branch. They work for us. So this proposition is really laughable. Your comment?
Yes, because she this is like the magician's hand to distract while they're doing the trick. Because the reason why I quoted from three other from one other, but I included as exhibits three other Mr. Seidel's declarations is to demonstrate the difference of how exhaustive, how professional, how fully compliant with FOIA he was in that other case that is in DC, and how in our case the response was conclusory and not factual. Okay, the denial is not supported by FOIA, and that's why she's going on into the CRS. Look, we don't have an expertise on FBI records. However, Mr. Seidel went in detail to all the efforts, all the man hours, all the 9,000 pages they produced for that in that other case, the Wright case in DC. So she's just trying to distract the attention from the court from what really matters, which is the differential treatment, the discriminatory treatment that targeted justice gets at any FOIA it files in any agency. That's what I'm bringing the attention, because we have two sworn statements by the same man that are drastically, different and opposed. So yeah, we did create a fact issue, and the fact issue is that they have the documents, they can produce them, but they don't want to do it because he admitted it in the sworn statement, because he would have to engage a few offices. That's
Mm.
not exempted in FOIA. In fact, he doesn't even dare say it's an unreasonable request because he knows it is not. He doesn't even dare say that under oath.
So we're cautiously optimistic that the judge will see through all these manipulations and the word when they say these words, they don't even mean it because in the next document they contradict themselves. So the judge need to see through it, the public needs to see through, and the Congress needs to see through it. Moving on, this is an update on a different case. This is one of the CARE cases, Council for Arab American Relations. And Mr. Abbas is the leading attorney for that, and he brought several cases, like the Thicker case, which was the Supreme Court unanimously passed the judgment in favor of the plaintiff. This one is actually has a public figure at the helm of at the top of the plaintiff's listing. It's a Mohammed Karula, and he has been a mayor of Prospect Park, New Jersey since 2005 and won four re-elections, and he's still a mayor. And this case was a follow-up on the Secret Service refusal to allow him to attend a celebration of Ramadan or the beginning of Ramadan at the White House. So it's a very public event, and it's a very public figure who there are multiple plaintiffs, but he's at the top. So, so in this case, the plaintiffs argued that their inclusion in TSDB violates their constitutional rights, specifically their Fifth Amendment rights to due process and equal protection. And the TSDB was never approved by Congress.
That case was filed in Boston, in Massachusetts, because this is my perception. Because all the circuits, the seventh, the second, the all the circuits had the fifth had ruled in cases, in care cases, and the only one that has been positive for the position of care and also our position, obviously, is the Ninth Circuit with FICRE. But most other circuits had been, had not, for example, in the Fourth Circuit, we had at the district court level, we had Judge Trenga that had ruled that the TSDB was unconstitutional, and then the Fourth Circuit Court of Appeals reversed it. And so the only circuit that has not expressed itself is the First Circuit, which is the one that goes after Boston. So I think that's why they filed it there. But they're, I think I don't know if we're gonna discuss. They're in this fight to transfer it, and that case is really very. It's like our lawsuit. It's so detailed and so based on facts that FBI has admitted from the discovery in other cases, that it's just very solid. And what these people are so scared of is of having to answer the complaint, because when they answer the complaint, not the motion to dismiss, but when they have to answer paragraph by paragraph, they have to admit to the things that they previously admitted in other cases.
Recently, this is what's been happening in this case recently. In April 24, defendants filed a motion to transfer the case to DC, or alternatively dismiss for failure to state claim. I've never seen such a blatant admission that, look, if we transfer it in DC, we will dismiss it for failure to state claim, or you can just do it right now. That was almost laughable. And so plaintiffs filed opposition to that motion in May. And finally, the judge scheduled a hearing on the above motion, is and it is set for November 21st, 2024. So we will be expecting an interesting conversation there.
Let me tell you something, because the interesting thing about this case is, all the care cases, they want to detach themselves from the targeted individuals because they don't want to be called crazy, right? But here's the thing: in that lawsuit, they include people that are on the TSDB but not on the no-fly or the selectee list. So they are attacking the same things we're attacking, but on other grounds. They're just saying we don't get jobs, we don't get this, we don't get that, and it's really interesting. No, it's not gonna. It probably will be like a Zoom call between them, but it won't be public. I don't think it would be.
There are several lines of argumentation, but what I like about this case that the attorney separated the effects of watch list placement beyond travel. And this is where we are. So beyond the no-fly list, what are the consequences of being placed? And they're arguing that it is inherently stigmatizing. And it affects rights and reputation when the government disseminates information about listees through NCIC, along with handling codes to 10,000 of public and private entities that instructs those entities on what to do when encountering people on the watch list. And then they make an argument that, by the way, the reason that it disseminated through NCIC is it is beyond statutory and regulatory authority on CIC, because it's supposed to only disseminate criminal information. These people are not criminals. They don't have criminal record, or they have not committed a terrorist act. So this is even the use of NCIC for distribution is beyond its statutory and regulatory authority. Great point. Then the financial implications. The Department of the Treasury disseminates the watch list to banks and other financial institutions in a manner that's designed to get them to prevent those on the watch list from maintaining accounts or conducting wire transfers. The same thing that we claim. And finally, it interferes with access to events such as the Mayor Karula could not attend the White House event, employment opportunities, especially those that require a security clearance. It interferes with the immigration process and gun ownership. There's no travel here. There's no boarding the plane. This lawsuit actually expands to those effects that we also claim. So that's why I like this lawsuit very much.
One of the things that I don't know how to tackle is the fact that the government criminals threaten judges. And if they're not mind controllable, they could be threatened. And something has got to happen to protect these judges from that pressure, because you know how the criminals come and kill your dog, and or just do atrocious things, and these people need to be protected from these criminals, because if Mr. Karula here prevails in this lawsuit, all of us, all of us will be benefited, and the criminals don't want that. So it's not just about these plaintiffs that they have as defendants, like 28 people in this case, including a lot of people from DHS, the people from the Treasury Department. So that's one thing that maybe judges can demand from Congress. We need protection. We are being threatened. You know.
In my mind, the best disinfectant, of course, is sunshine. So we need publicity. So perhaps there should be more publicity surrounding these decisions, especially when they're so clearly biased toward the government defendants. That's the update on this case. And right before we wanted to do a podcast, Anna, you sent me a fabulous lawsuit, also by CARE, by Council for Arab American Relations. It was filed just in August of this year. Two plaintiffs are American Palestinian naturalized U.S. citizens. And I couldn't read the entire 69 pages, but there's a lot of meat in their description of the factual background. They actually describe the nomination process, and I want to, as soon as we're done with this podcast, I want to deep dive into these factual backgrounds, because they are describing the very expensive violation that TSDB, that every branch of TSDB from nomination to distribution has, and how Customs and Border Protection policies violate the constitutional rights of TSDB listees. And I would, of course, expand it to, beyond travel. And they have 6 different counts that they claim violations of. It's a violation of the Fourth Amendment, illegal search of electronic devices. It's a violation of plaintiff's self-incrimination right, violation of the Fifth Amendment, procedural due process, and then also the substantive due process, violation of Administrative Procedure Act, and lack of statutory authority to create and maintain the watch list. It echoes the Karula case, where they said, listen, the government cannot show us the statute that created the watch list and dictates the procedures around it. Instead, they have vague proclamations and vague quotes from just the generalized quotes like we need to defend national security, we need to protect American people, but that's not the same. And TSDB affects so many people, life of so many people domestically and around the world. Anna, please tell me how you feel about this case.
Well, I absolutely this complaint. Let me tell you, as I have said to many people, everything, not everything, but 80% of what I learned about the program, I learned through Lighthouse. Right, he taught me, and then I did the legal research of the care cases and everything that has gone on in the past 20 years in litigation, and then actually 18 when I got here because it's been 2 years since I'm here. But the thing is that even Richard, when he read this lawsuit, he said to me, there must be some good whistleblowers selling them information, because even he didn't know some of the information that is so accurately alleged in that complaint. So I urge everybody to look it up. If you go to the CARE website, they have the complaint there, and for all of those, even pro se litigants, you should definitely read and follow this example, because it's a jewel. It's an absolute jewel. And we alleged most of those constitutional
Violation.
violations in our lawsuit. But the facts, the chronological, and they on these, one of the important things about this lawsuit is they included the CIA, the NSA. So they're including everybody, everybody in this lawsuit. So something has got to give. I think this is the best document I have seen of all the documents I have seen from them. This is just, it's absolutely perfect.
Thank you, Anna. This is it for our podcast. It's a shorter podcast, but we gave you a legal update concerning four cases. We discussed the dismissal of Target Justice v. Garland by the Supreme Court. We discussed the FOIA request based case filed by Target Justice about the dead people removed from handling codes 3 and 4 in the TSDB. We discussed the third, we discussed the CARE case with Mayor Karula, who was not admitted to not allowed to be in the White House during the celebration of Ramadan. And then the fourth, the most recent case that we have high hopes for, it's called Irshaid v. Garland, and we will be tracking those lawsuits for you, and then we'll be learning from them, and that gives us hope.
Yeah, well, that we also have the two other pending litigations. One is demanding all the memoranda and documents regarding the exemption from the reasonable suspicion requirement to place anybody on the TSDB. That was a FOIA request that I sent on behalf of Targeted Justice, and the government is reneging on it, and they don't want to produce that evidence. We had a hearing last week, and it also, all the usual suspects, usual excuses. Imagine I made the FOIA request on behalf of a media organization called Targeted Justice, and the Office of the Attorney General, to whom the FOIA request was made, sent it to the FBI for them to check the documents. And, I argued to the judge. I said, I didn't do a FOIA to the FBI. I did it to the Office of Attorney General that is above the FBI. So they have not produced a single document. And I think that a lot of the things that are happening is also the election. I think they see coming a change of administration, and things should drastically change too, even in, like you say, sunshine, a bringing light to the darkness. And then the other case that we have pending, which is the same thing, they have not produced. They produced one audit report that I already had. They said that it's against the Office of Inspector General. It's another FOIA request, and they have not provided me with a sworn statement. They have not provided me with the correspondence I asked for. So now the court ordered me to do discovery, and the court anticipates, and I know they're going to do a motion for protective order, and then you're going to reply to it, and it's a never ending, because that's what the government is there for, to make you get tired. But I am telling each one of you, I am not getting tired, because I have a tough act to follow with my father's example. Okay, for those of you that have learned it, or have heard the story, please excuse me. He was born in the boonies without being able to walk in a, a in the year 1917, and he that didn't stop him from going to high school, to college, to Wharton Business School, to the University of Law School of Puerto Rico, getting the best medal, to being a professor at the University of Puerto Rico for 34 years, to having three daughters, to just being somebody that everybody absolutely loved and so charismatic. And so I grew up uh, going with him places, with him to court, going with him places, and seeing how much effort he put into it, but he never gave up, and I am not giving up, because we are all going to be free. I don't know when it's going to be, but I am not going to give up, because this is highly illegal, and what we do need is more exposure. The moment people realize that our government is torturing innocent people, not just in the United States, but also around the world, it will stop. But right now, they don't believe it's true. So that's what we need to very cohesively, very eloquently explain it to people. And the best way for you to do it is share our content in Rumble. It's Real Targeted Justice Channel. Share these podcasts, these Len podcasts. Choose your favorite one. But share the symposiums that we have done with Vax Choice, with Todd. So you don't make it about yourself. You have another person talking about this atrocity, this Holocaust happening in real time, perpetrated by government criminals in the United States government.
Thank you, Anna. Very inspirational, and I highly recommend following Anna's Substack because recently you've been on a roll. I read some of the most inspirational podcasts from you about your story, about your father. We're all people, and stories is how we communicate our positions, and you express it so beautifully and personally. So I highly
Thank you.
recommend.
Thank
And
you.
so this is the end of the podcast, and I want to share echo some of the notions that Anna expressed before. Uh, Listen, we will not stop fighting for your freedom and for our freedom. And I'm not only speaking for myself, but also for the leadership of Targeted Justice. For as long as we can speak, type, podcast, we're not going to retreat. Just the opposite. We're expanding our advisory board. A whole bunch of new officers and VPs are coming on board to manage roles from public relations to international leadership. And no amount of hacking and government intervention, nor unfortunately defamation by our fellow targeted individuals will make us stop. If you engage in this behavior, you are working against your interests. Targeted justice again and again proves its honorable goals. But the further we get, the more defamation we experience. I guess it simply comes with the territory. And I want to leave you with this thought. Our dedication to our shared mission remains unshakable, even though it's been tested over and over. Regardless of what you say and do, we will still fight for your rights. Until next time.